We are especially honored to have our next speaker. I'm sure you recognize Dick Thornburgh. You've heard his name. You've seen him on TV. He served as governor of Pennsylvania and as an attorney general of the United States of America. Dick Thornburgh.
Thank you very much, and good morning to you all. It is a pleasure to be here and share some views on some very important issues. I needn't labor the point that white-collar crime is very much on the national agenda, and particularly in the aftermath of the Enron and WorldCom debacles, and present-day focus on mutual funds, hedge funds, backdating of stock options, insider trading. The list goes on and on. When I was at the Department of Justice, we used to call them crime in the suites. And that is a real focal point, I think, for law enforcement at all levels today. I want to focus on a very narrow issue, but an important issue, I think. In Washington, occasionally we find ourselves consumed with the issue du jour, and oftentimes that's of appeal only to specialists. I'm going to make the point today that the controversy over the attorney-client privilege is not one that is of interest simply to lawyers, judges, and academics, but it has a much broader area of concern that affects all of our citizens and indeed the well-being of our free market economy. In every case where investigations of wrongdoing take place and a corporation is a prospective defendant, prosecutors are called upon to make fine judgments as to whether or not the corporation should be charged or that individual rogue employees may be the source of the wrongdoing. This decision can have dire consequences, as indicated most recently in the prosecution of Arthur Anderson, which, although eventually their conviction was reversed in the Supreme Court, that was long past the day that the auditing firm was out of business because of the criminal charges brought against them. And that's pointed up by the lengths to which KPMG went to avoid criminal prosecution with respect to some tax shelter cases they were involved in, paying a fine of $456 million to avoid criminal prosecution of the firm and restricting the prosecution to 12 of its employees. To help in making these decisions, the Department of Justice in the latter part of the 1990s and the early 21st century issued guidelines, initially the Holder Memorandum and more recently the Thompson Memorandum, which are designed to provide a template for prosecutors in deciding whether or not to charge employees or to charge the corporation. It sets forth 9 factors, and I won't recite those in any great detail, but I want to focus on one which calls upon the prosecutor to take into account the nature and extent of cooperation extended by the corporation to the investigators and prosecutors in the course of their investigation. That cooperation is a factor that can result in a corporation not being charged. The most controversial piece of the cooperation package is, as indicated earlier, the corporation's willingness to waive the attorney-client and work product privileges which exist in the law and have existed since Elizabethan times. The attorney-client privilege is probably the oldest privilege that the law knows, and its purpose was set forth by the Supreme Court in the Upjohn case very clearly. The court said, the attorney-client privilege encourages full and frank communication between attorneys and their clients, and thereby promotes broader public interest in observance of the law and the administration of justice. I don't think anyone would question that. In examining our practices on a day-to-day basis, that we find it absolutely necessary to have a candid explication of the facts in a particular situation by the client to the lawyer in order that judgments may be made as to the advisability of a proposed course of conduct or culpability in any past course of conduct. Since these guidelines have been adopted by the Department of Justice, they have provoked a great deal of reaction on 2 counts. One, there has been a ripple effect as the Securities and Exchange Commission has, in its Seaboard rule, adopted a similar rule in investigations undertaken by that agency. The Sentencing Commission incorporated the willingness to waive attorney-client privilege into considerations of cooperation at the time of sentencing. State organizations and stock exchanges, and even the auditors, often now moving to, in order to give a clean audit to a corporation, will insist on waiver of the attorney-client privilege. The reaction has been strident, I think it's fair to say, and uniform across a surprising number of areas involving practice before these agencies. The American Bar Association House of Delegates unanimously passed a resolution calling for the Department of Justice to abandon this feature of the cooperation consideration. The last two presidents of the ABA have communicated directly with the Attorney General in the same tenor, and a task force of lawyers from across the country have been working hard to try to alleviate this situation. A broad coalition stretching from, on the one hand, the American Civil Liberties Union, on the other hand, the Association of Corporate Counsel in America, and I don't think you can get a more diverse group than that, have taken the same position, calling for the reexamination and, in fact, abandonment of this rule. The courts have become involved in examining the Thompson Memorandum in the KPMG case, finding other factors not related to the attorney-client privilege, but equally important, to be unconstitutional denials of rights to employees who are subject to investigation. Thus far, the Department of Justice response has been somewhat troubling, because they really have issued only the so-called McCollum Memorandum, which is designed to have each U.S. Attorney's Office adopt in writing a protocol with regard to waiver, and affirm the decentralized nature of this decision-making. There is no overall view expressed with regard to this important privilege by the Department of Justice through the Attorney General or the Deputy Attorney General. The results of this seeming impasse thus far are equally interesting, I think. The Sentencing Commission, after those of us who opposed their adoption of this rule testified before them in the spring, simply abandoned their aping of the Department of Justice on the attorney-client privilege, and as of November of this year, no longer have that as a factor to be taken into account at the time of sentencing. Hearings were held before both the House and Senate Judiciary Committees, and on a bipartisan basis, sentiments were expressed opposing the Department of Justice's rules in this regard. Yesterday, Senator Arlen Specter, the outgoing chairman of the Judiciary Committee, introduced a bill which would legislatively terminate the Department of Justice practices in this regard. And at least one commissioner of the SEC has indicated clearly that he would like to see the SEC withdraw its emulation of the Department of Justice in this regard as well. I think that what we're talking about here is a factor that really is important in the day-to-day practice for those of us who represent corporations. This shortcut imposes an overwhelming temptation on the Department of Justice to make the demand for waiver the rule rather than the exception. And indeed, it creates a temptation on the part of corporations, which are desperate to prevent criminal charges, to accede when this is stated government policy. And I think lawyers, as I indicated earlier, have a very key role in helping companies comply with the law, but they have to have the confidence of the managers and the board of directors and the corporate employees to get all the relevant information so that they can properly represent them. And the waiver policy currently in place in the Department of Justice and other agencies simply discourages companies from consulting with its lawyers and hamper, in particular, the conduct of internal investigations, which have become an increasing phenomenon in the effort of corporations to, on their own, get to the bottom of any allegations of wrongdoing. And this harms not only the company, but the public as well. in sum, I think that we have once again to look to the Supreme Court for an assessment of how important this is. In the Upjohn case, the court stated, if the purpose of the attorney-client privilege is to be served, the attorney and client must be able to predict with some degree of certainty whether particular discussions will be protected. An uncertain privilege is little better than no privilege at all. And that is precisely where we stand today in terms of the viability of the ancient and honored attorney-client privilege. It is made uncertain by these actions that have been taken by the Department of Justice and emulated by other agencies in the course of their investigations. So I think in dealing with this particular issue du jour, we have to look beyond the particular concerns of the parties who may be involved in a particular investigation and look at the overall effect it has on the integrity and sanctity of this important privilege and on the administration of justice as a whole. Thank you very much.